Bismillah ar-Rahman ar-Rahim, the procedure of judgment in the Hanbali school. Alhamdulillahi Rabbil Alameen, salatu salam ala Rasul Kareem, Rabbana taqabbal minna, zidna ilma wa hikma wa huda, wa sallallahu an yuwafiqna lima yuhibbu wa yarda. Allahumma salli ala Sayyidina Muhammad, abduka wa rasuluka, nabiyyan ummi, wa ala alihi wa sahbihi wa sallam taslima. A'udhu billahi min shururi anfusina wa min sayyiati a'malina. Allahumma atina nufusana taqwaha wa zakkiha. أنت خير من زكاها توليها ومولاها اللهم شيوخنا أما بعد. All the praises belong to Allah subhanahu wa ta'ala. Everything happens in the world by Allah subhanahu wa ta'ala. Yarhamukullah. And may the peace and blessings be upon Allah's Prophet Muhammad sallallahu alaihi wasallam, which the messages keep continuing with us and in the future. May Allah subhanahu wa ta'ala send his blessings upon Prophet Muhammad sallallahu alaihi wasallam and spread the legacy of Rasulullah sallallahu alaihi wasallam. So we're going in the Hanbali school, Imam al-Sunnah Ahmad Ibn Hanbal, who mentions the things from the hadith from Rasulullah sallallahu alaihi wasallam. We're going on the Sifat al-Qadha, means the procedure of the judgment. We're going through the rules based on that. Would you like to read the first one, Brother Sheikh Ibrahim?
Bismillahir Rahmanir Rahim. إذا جلس إليه الخصمان فدعا أحدهما على الآخر.
Yes. So what happens is they go in front of the judge, the qadi, and what happens is one of the two litigants, they sit there, the two people, and like just now, like you have the same thing in the courts that you have now, you have the two litigants, the plaintiff and the defendant. And the plaintiff is the one that's called the da'i, the one that's requesting, and the da'i alay is the defendant, the one that defends himself. So they go in front of the judge. Well, that's what it's called. The litigants are the two people there, the plaintiff and the defendant. That's what you have. In Arabic, they call it the da'i and da'i alay. Okay, is that clear on that? And the script that's there? Okay, to read number 2, Brother Musa.
لم تسمع الدعوي إلا محروة كحيرة يعلم به المزع عليه.
Yes, so the claim is not heard unless it's clear on what they brought out and exactly defined. And the Sheikh, he mentions that on the next things on how it should be clear, not something that's ambiguous or something that the person they don't know for sure. So sometimes the judge will make sure that the things are clear of what the person they're asking for, and that's just mentioning that. So number 3, Sheikh Hamza.
فإذا كان دينا ذكر قدره وجنسه.
Yes, if it's a loan that the person they're asking to be paid back, then the person they have to know exact amount and what type of loan it was. Now the person say, oh, this person owed me money. Then they go to the court, to the judge, and then the judge says, this person owes me. They say, how much does he owe the money? I don't know. So not like that. So they have to be clear on what the plaintiff is asking for, and also what type of loan. So if it's a loan, it has to be exact what the amount is, and also it has to be the exact type. That's why you see Allah subhanahu wa ta'ala mentions in the eye of Dain that you have 2 witnesses and you write it down so it doesn't become confused afterwards how much it is. Like Allah tartabu, the people they don't have doubts about it. So that's what happens. So that's the first step when you go in front of the judge. It has to be exactly clear what the person they're seeking for. Did you read the next one? Next, Brother Ibrahim, number 4.
وإن كان عقارا ذكر موضعه أحد.
Yes. So if it's property, then the person has to mention the exact location or the exact place it is. Not say that, oh, this person has a land somewhere, but just be specific on what the details are. So you'll be exactly clear on the things of the person they're asking for. Okay, to read number 5.
وإن كان عينا حاضرة عينها.
Then if it's something that's specific that the claimant is asking for, the plaintiff is asking for, then he's got to specify what it is, exactly what it is. Ayn means specific on what it is. You know? So that's what. And sometimes what would happen is they would bring the object to the court, and the plaintiff would point at it what it's about. He would specify what exactly it's about that they're discussing over. So sometimes that would happen. So that's what that point is, to be specific on what the item is. Not say that this person owes me for this, and it doesn't specify what exactly it is, but to be specific on what it is, so specified if it's there present in the court. Okay, read number 6.
وإن كانت غائبة ذكر جنسها وقيمتها.
Yes. So if it's not present there in the court in the trial over there, then the person has to specify what type it is and where it is and the value of it. Be very specific on the details. So these are the things that the Sheikh mentioned, to be very specific on the details on what the object is and what the things are. And you see in today's day and age, if you see the courts in America, they have a statute of limitations they have. So if a person, they wait too long, the judges won't even look at the case because the things aren't going to be clear. It's like 5 years, more than 5 years, you can say we're not even going to look at it because from 5 years later, who knows what happened? There's going to be a lot of confusion about it. So these are the same points like the Sheikh mentioned over here, the Ibn Qudamah, and when the person, they come to the court, they got to be exactly specific on what they're talking about, not any confusion whatsoever. Okay, let's go to number 7. Next.
ثم يقول لخصمه ما تقول.
Yes. So then they start out, they ask the plaintiff, this is what do you say? What is your concern about? To start out, that's a procedure for it. So it goes step by step on the procedure to go through. Okay, Musa, you read the next one, number 8.
فإن أقر حكم المدعي.
Okay, can you read the English, number 8?
If he agreed, the judgment is for the plaintiff.
Yes. So the plaintiff would come and say, my concern is this person owes me $1,000, or this person did this damage. Then he asks the defendant, do you agree to that? So if the defendant agrees with it, then the case is over. That's it. Plaintiff has the charge and the defendant agrees to it, and that's it. The case is done. So that's the first thing that's immediately done. If the defendant agrees to the complaint or the inquiry from the plaintiff, then the case is done and over. Okay, who's next? Ma'am Faisal, you want to read one?
Oh yeah, number.
Number 9.
وإن أنكر لم يخلو من 3 أقسام.
Yes. So what happens if the defendant denies the claim, where the plaintiff says, oh, you owe me 1,000, or you did this or that, and he denies it, then there's 3 possible cases. One, if that object is in possession of one of them. The second one, if they both have possession of it, like for example, both of them are staying in a house, so they're both in the possession of the house. And the third possibility is if somebody else has possession of the object. So those are the 3 scenarios that the Sheikh mentions. So he talks about the first one, if one of them has possession of the item in concern. Okay, so to read number 12. Who's next?
12 or 10?
Which one? 10? Okay, number 10.
Sheikh Ibrahim.
Ibrahim.
You're bringing it out.
Number 10.
أحدها
Yes.
أن تكون في يد أحدهما.
Yes, so the first of the 3, if it's in the hands of one of them, that means one of them possesses it. There's 2 parties there, the plaintiff and the defendant. So if one of them has possession of it, that's the first scenario. Okay? The other 2 is the second scenario, is if it's both in both their possession. And the third one is if it's in neither of their possession, somebody else has it. So he talks about the first one. One of them has possession of it. Okay, read number 11.
فيقول للمدعي أنك بينة فإن قال نعم وأقامها حكم له بها.
We read number 11.
Yes.
Okay, could you read it again?
فيقول للمدعي أنك بينة فإن قال نعم وأقامها حكم له بها.
Yes. So the judge says to the plaintiff, do you have any evidence, any proof? And if the plaintiff says, yes, I do have the proof, that he shows it to the judge, then the judge makes a judgment based upon it, upon the proof that the plaintiff has. And that's the basic rule in the book of judgments. The plaintiff, he has to bring the proof, da'i, he has to bring the proof, and on the defendant is the swearing, is the yahlif. So that's the basic ruling that they have. The plaintiff, he has to bring the proof of what he claims that the defendant owes to him, and then the defendant, if he denies it, then on him is the swearing. He makes a swearing that what the plaintiff is saying is not true. That's the basic rule for it. So that's how you start off. The judge asks the plaintiff, what's your evidence of your claim? And so then that's what goes. Okay, then read the next one.
وإن لم تكن له بينة قل فلك يمين.
Yes. So if the plaintiff doesn't have any evidence, then he goes to the defendant and it says, on you is the swearing that what the plaintiff is saying is not true. So that's the next step. If the plaintiff doesn't have any proof, any evidence, then it goes to the defendant, and the defendant, if he disagrees with the charges against him, then he makes the swearing. You know, he does the yahlif. Okay, so the plaintiff will have the proof, and the defendant will do the swearing to deny it. Okay, read the next one, the hadith from Rasulullah sallallahu alaihi wasallam. I think that's the next one, right?
Sheikh Ibrahim is no longer available.
Oh, okay. Okay.
He's on quiet mode.
Yes, okay, inshallah.
وإن لم فإن طلبها استحلفه وبر.
Yes, so we talked about that, right?
Yes.
That if the plaintiff doesn't have the evidence, then the defendant, he makes he makes the halaf, he makes the swearing. And you read the hadith, the next one.
Sheikh Ahmad.
يقول رسول الله صلى الله عليه وسلم لو يعطى الناس بدعواهم لادعى قوم دماء
You can read the English, you don't have to read the
رجال وأموالهم ولكن اليمين على المدعي عليه. The saying of the Messenger sallallahu alaihi wasallam, if people were given what they claimed, some would claim the blood and wealth of others, but the oath is upon the one against whom the claim is made.
Yes. So what Prophet Muhammad said, if the person was granted everything that they claimed for, then people would take other people's property and blood. Because anybody can say anything and take anything from anybody else. So that's not how that works. So that's why Prophet Muhammad said, so proof is on the one. The person has to come up with evidence that the other person owes him something or is liable for him for something. And then the defendant, if it's not true, then he has to take an oath that what he's saying is not true. So that's what Prophet Muhammad said. So he's repeating the points that he made earlier. On the plaintiff is the proof. He has to show proof that he's owed that, or he's liable, or he's given the liability for that. And the defendant, if he disagrees it, then on him is to take an oath to say that what it is not true. And the judge has to make a judgment on it. And some of the ulama, they look at a person taking the yameen, the oath, and the swearing to be as strong as the proof. Sometimes they say that. So that's a very strong.
What if they both take the oath?
Yeah, it talks about that. What the
It's
next step
coming in number 17.
Okay. Who's next? We read the next one.
Thanks.
Okay.
17? Oh no, which number?
No, 15.
Yes.
وإن نكل على اليمين وردها على المدعي استحلفه وحكم له.
Yes.
If he refuses to take the oath, it returns back to the plaintiff. The plaintiff is now made to take the oath.
Yes.
And a ruling is made in the plaintiff's favor.
Yes. So what happens is the plaintiff first, he brings up the charges, and then the judge asks him for the evidence or the proof. Then it goes to the defendant. If he doesn't have the proof or evidence, then it goes to the defendant, and the defendant is asked to do the swearing, to do the yameen. And if he refuses to do the swearing, the yameen, then it goes back to the plaintiff.
Why might
And
the
the judgment is
defendant
for the plaintiff then, in other words.
Because he fears Allah a little bit in his
Yes.
heart.
So the plaintiff is given the judgment because the defendant refused to take an oath or take a swearing that it's not correct, the charges against him. So it goes back to the plaintiff, and then he just takes the oath, and then he's given the judgment for the plaintiff. So in that scenario. Okay, is that clear so far, the steps?
What if the defendant doesn't fear Allah and he makes a false oath?
Yeah, the judge has to make that determination, so it goes to the judge to do that. So then the plaintiff has to come up with the proof and the evidence.
Oh, I see.
That's
But
what
if
happens.
justice doesn't happen in this world, then
What if it's the evidence of the plaintiff against the oath?
The judge has to look into it, so usually go by the evidence. That's what you do. The judge has to decide on it, on the case. So that was the first point. You know, if the plaintiff has the evidence, the judge bases it on that evidence. He doesn't even do the oath. That's what the Sheikh said in the beginning.
Oh,
Then
okay.
after that, if he doesn't have any evidence, then the defendant has to take an oath. And if he refuses to take the oath, then the judgment goes to the plaintiff after he makes an oath that what he said is correct.
It's getting even.
Okay, so far steps so good. Okay, inshallah. And keep in mind that in the akhirah, Allah subhanahu wa ta'ala will give the judgment to everybody, regardless of what happens here in this world. So a person they should fear Allah subhanahu wa ta'ala and bear that in mind, inshallah. Okay, to go to the next one. The next, Musa, you need the next one there.
Sheikh Hamza.
وإنك لأيضا صرفهما.
Yes. So then if the plaintiff also refuses to take an oath, they both don't have any, the plaintiff doesn't have the evidence, the defendant refuses to take an oath, and the plaintiff refuses to take an oath, then the case is adjourned. You know, it's
What does
not
adjourn
judged.
mean?
I mean, it's not judged, it's not decided on whose favor it is. It's just adjourned, it's taken care of later. That's what it means, adjourned. That the judgment is not given at that time, but it can be brought again in the future. Okay, let's go to the second page.
وإن كان لكل واحد منهم بينه حكم فيها للمدعي.
Yes, so if both of them have the evidence, this is here. So the Sheikh over here, he says, Ibn Qudamah, he says that the judgment goes to the plaintiff. So let's say both of them have the evidence, plaintiff has the evidence and the defendant has the evidence. And let's say they're both equal, supposedly they're both equal. Then who does the ruling go to? So over here, the Sheikh, he says, Ibn Qudamah, he says it goes to the plaintiff. Okay? That's where it goes. Both of them have evidences. And this here, if you look at the commentary on it, they say there's different views in the Hanbali school. Some of the Hanbaliya, they say that it goes to the defendant gets it, if it's equal on both sides. And some of the other ones say, no, the plaintiff gets it, so it's like, you know, so that's the case there. But over here, the Sheikh, he says that it goes to the plaintiff because the plaintiff went through the effort to bring the case up to the court. So it's more likely that what he's saying is correct. So that's what he said. But there's different opinions in the school, in the Hanbali schools. It's not just the one thing. But over here, the Sheikh, he says that it goes to the plaintiff in that particular case, if both of them have evidences on their side. Okay, read the next one. Next.
Isn't there also a rule that the basis is freedom of guilt?
But there's a
And
basket.
like, so this
It's
person
not gonna
is
get there,
claiming
you know.
you owe me money, and he's proving that I don't owe him money, and then they both have equal evidences. So wouldn't it just revert back to the?
Yeah, that's the
basis?
other opinion in the Hanbali school. So
Oh,
that's
I
what they say. So people that have their reasoning why they say that.
Oh, I see.
So that's the argument that they give with the other opinion in the Hanbali school. So both are there in the Hanbali school.
I see.
All right, inshallah. See the next one.
وإن أقر صاحب اليد لغيره صار المقر له الخصم فيها وقام مقام صاحب اليد فيما ذكرناه.
Yes. So if the defendant, he says that this property is no longer with me, then whoever has that property in his possession, he takes the place of the defendant. That's the point that he has. No, like let's say that a person, let's say this person has this car belongs to me, and then he brings it to the court. Then the defendant says that I don't have this car, it's with the other person over there. So then what happens? The other person takes the place of the defendant because he's in possession of the car currently. So
No,
then-
even if he just has it for like a little bit. Like, what if he just has it for a little bit?
Yeah, the judge has to look into it, make the
Okay.
judgment on it. So that's the case. If he says, I don't have possession of it now, it's in somebody else's possession, then that person, he takes the place of the defendant. Because the person wants his car back, So if it's with this person and you gave it to somebody else, and it's with the other person now. Okay, so that's a point that he made there on number 18. Okay, let's go to the next one, number 19. That says both of them have possession of an item. Can you read that next?
الثاني أن تكون في يديهما.
Yes, in the hands of both of them. Like for example, if both of them are staying in a house, for example. So in the hands of both of them. So what do you do in that case?
Yeah.
Okay, read number 20.
فإن كانت لأحدهما بينه حكم له بها.
Yes. So if one of them has evidence, then the judge bases the judgment on that evidence, on the proof that he goes. So he bases it on that proof and the evidence. That's what he judges by. That's the first point. He gives a judgment based on that. Okay, read number 21.
Yeah. So. Okay. وإن لم يكن لواحد منهما بينة أو لهما بينتان قسمت بينهما.
Yes. So if neither of them have evidence, or both of them have evidence, then it's divided between the two, because they're already both in possession of it, so it stays like that, They're both still in possession of it.
Is possession considered an evidence? Like somebody says, this is my car. You say, what's the proof it's your car? He said, I have the keys for it.
Yeah, that's what they say. There's more details to this. This is just the what you call the summary. So if you look into the details in the books of the Hanbali fiqh, they go into details about that. I erased that part there. He was talking about that. Somebody they claim it's all mine, or other one claims half. That it gets confusing, so I just left that out. But you can look in the commentary, and they have another book called the Mughni. The Mughni is about 40 volumes. So it goes into extensive detail with all the madahib, what they rule on those things. So just to keep it simple.
Some squatters, what they do is they'll break into a house, and then they'll go live in the house. And then when they say, "What's your proof that this is your house?" They say, "I live here. This is my proof."
Yeah, the judge got to be a sharp person, so he's got to know what the reality is. And things like that. It's really false witness.
Yes.
That could be also additional punishment on that, also criminal punishment for that as well.
Yeah, they do that a lot in the market. They'll find like a house that's tax repossessed.
Even it could be the extent of cutting the hand. That much. The person they're stealing something, right? You can go that far, but the judge can decide additional things for it too, besides just the judgment. Okay, shall I read the next one? Number
22.
وحلف كل واحد منهما على النصف المحكوم له به.
So if they both keep possession of it, like in the beginning, then both of them take the swearing. Both of them swear to it, and then it's kept that way. They're both divided into the thing. Is that clear on that point, Musa?
Yes.
Okay.
Can you repeat it again? If they both have possession,
They both take an oath and they split it. Yes. Yeah.
So if both of them have evidence or neither of them have evidence,
Right.
then it's divided,
Yes.
and
It's
each
split.
of them swears what do they have to swear?
They swear that this belongs to me, and then
Okay.
it's
So
kept
let's
as a-
say like Musa and Sufyan, they both grab a cookie at the same time.
Yeah.
And they say, "This is my cookie," and Sufyan says, "No, it's my cookie," and then they go in front of the judge.
What
The judge-
oh my God,
the
smoke
judge
is
will
coming
split
out.
it. The judge will split it between them. What happened, House?
Smoke is coming in the house.
Use a stick. Use a stick.
It's okay.
Come here. Use it.
I put it
Okay, so like Sheikh Faisal was saying, or Imam Faisal, he was saying the judge will split it between us, and then each of us swear to the half that we take.
Yes, both the parties swear to it, and they can keep they split it. So that's what the sheikh said that they do.
But what if I have evidence that I grabbed it first?
Yeah, the judge bases it on the evidence and sees
Then I
if the
take
evidence
it.
is valid or not.
Bro, we already covered that. That's number
Covers
20.
that if there's evidence for
That's
it.
number 20, bro.
All right, inshallah, is that the last point there? If they both have possession of it?
No, there's a
23.
23?
I see it. وإن أدعاها أحدهما ودعي الآخر نصفها ولا بينة قسمت بينهما.
Yeah, so it's like the same thing as the previous one. If they both claim to it, the judge divides it. But if one says it all belongs to me, and the other one says, oh, only half of it belongs to me, then it's the same thing. It's divided between the two. That's what the Sheikh is saying. If there's no evidence, there's no evidence, and
So
that's why.
it still only gets half the property.
It's split between the two, the same as the previous point. Okay, let's go to number 26. That's if it's in the possession of somebody else.
Okay. الثالث أن تكون في يد غيرهما.
Okay, that's
Third,
the next
if it is in the possession
of somebody
of
else.
someone else. So the cookie, both Musa and Sufyan are fighting over the cookie, and then Maryam comes and grabs the cookie and runs away with it upstairs.
Okay, so that's the third scenario. Neither of them have possession of it. It's in the possession of somebody else. So what do you do in that case? Do the next one, Brother Hamza.
27.
27. No, I didn't skip a bunch of numbers. وإن أقر لأحدهما أو لغيرهما صار المقرر له صاحب اليد.
Yes. Okay, the one that has possession of it, then you ask him, who does this belong to? He says it belongs to this person, then it's given to that person. Who says it belongs to, who has the possession of it? That's the point that's there. If that person says it, because the person that has hold of it in his hand now, he's asked, who does this belong to? Then he's going to give the answer. Does it belong to this person or that person or so on? But then if he says it belongs to one of them, then it's just given back to that person that who he says it belongs to. Okay? Alright, that's the rule now. After that, it transfers to the person that he says it belongs to. Let's read number 28. Is that one we're on?
وإن أقر لهما صارت كانتي في يديهما.
Yes. So then if he says it belongs to both of them, then you go back to the second section where it's in possession of both of them. And you base the rulings on that, on the previous section. Remember there was 3 different scenarios. Then you go back to the second scenario where it's in the hands of both people. Yes? Musa?
So for rule number 27 and rule number 28, the translation says if he acknowledges it to, or if he acknowledges it to both.
Yes, that
Who
was
is he?
the third party that has the possession
Like
of the item.
Maria.
Oh.
So if he acknowledges,
and ran away with it.
if he acknowledges it belongs to one of them, then it goes to that one person he acknowledges to. But if he acknowledges it belongs to both of
So
them,
if Maryam Badi says it belongs to Sufyan, then Sufyan takes it.
right?
And if Maryam Badi says it belongs to both of them, then we go back to
The
scenario
second
number
section,
2.
the second scenario where they both have the possession of the item. The judge bases it on that. Okay, all right. So let's go to where we are. We're on 29.
وإن قال لا أعرف صاحبها منهما ولا أحدهما بينة فهي له.
Yes. Okay, if he says he does not know who owns it from the two,
And none of them has an evidence.
no evidence, then it is his. It's the one that he has possession.
Oh,
of.
okay. ولأحدهما. I thought it said ولا أحدهما. Okay. ولأحدهما بينة فهي
Yes.
له.
Yes. Okay, so if one of them has evidence that belongs to him, then it goes to him.
So if
He
Maryam Badi
doesn't say.
says I don't know who the cookie belongs to,
Yes.
and I have evidence
Yes.
that I grabbed it first,
Yes, so it goes to you.
then it goes to me.
He's not sure. The person, I'm not sure it belongs to. Then the person has evidence of it. It's given to that person. I think that's what that says, right? Okay, inshallah. So the last point, number 30.
Oh.
Go.
أو لكل منهما بينة استهما على اليمين فمن خرج سهمه حلف وأخذها.
Yes. So if it's not certain on who it belongs to on the two, then what they do is they draw lots, and whoever's lot comes up, then he swears by it.
If
He
both
takes
of
it.
them have evidence.
Yeah, both of them have evidence that it belongs to them. Then they draw the judge draws the lots at random, and whoever's lot comes up, then that person swears it and he gives it to him. So it's not really a judgment; it's just by lots. They have that in some situations. Prophet Muhammad says some did that. It's not gambling, but that's something to so that so the person they do justice, in that scenario. Okay, inshallah. So this is the procedure that the Sheikh mentioned in the judge. And the main point is that the evidence, the proof is on the plaintiff, and on the defendant is the swearing. That's the hadith from Rasulullah. So it's usually how it works, you know, on the judge cases. Okay, inshallah. All right, so let's go to the question and comments. Start with Hamza. Do you have any questions or comments on these issues?
How come for the last one when